Good evening. We'll just give it one more minute and then we'll get started. Good evening. If you're just joining us, we'll just be starting in 1 minute. All right. Well, good evening and welcome to the last lecture in Citizens Law School. My name is Anna Conley, and I'm a law professor at the University of Montana Law School. I am also the chair of the Law Related Education Committee, and I have been watching all of these lectures for the last couple months and learning a ton from my colleagues. I'd love it if any of you out there have seen all eight. Drop something in the Q&A and let me know you've been here all eight. That would be really impressive. Or if you've seen seven, that would be also really impressive. We will be sending out a survey in the next couple weeks to those people who signed up, and we would really appreciate it if you would share your thoughts. We're always changing it year to year and wanting to make sure that it's as useful as it can be for the public, for Montana, and for Montanans. And in that vein, I'm very excited to introduce my friend and colleague, Professor Constance Van Kley. Professor Van Kley teaches with me at the law school. She teaches federal constitutional law, Montana constitutional law, criminal procedure, adjudicative, as well as First Amendment. So, oh, I see Leah has listened on seven. Very good, Leah. Great. I'd love to hear from you about which ones you liked and what thoughts you have on how we can improve it. So without any further ado, I'm going to turn it over to Professor Van Kley. Please ask questions as you go. Professor Van Kley would love to make this a dialogue. I would love to make it a dialogue. It's more interesting for all of us that way. So don't be shy to drop a question in the chat and we'll be kicking it off. Go ahead. The floor is yours, Professor Van Kley.
Thank you, Professor Conley. I'm very excited to be here and to talk about the Montana Constitution with you all. The title is Do You Know Your Rights Under the Montana Constitution? We will definitely talk about some of the unique rights that are available to citizens under the Montana Constitution. But we are going to, um, sorry, just a minute because my Zoom seems to be, or my PowerPoint seems to be frozen. I'm going to open it up again. Okay. Uh, Thanks for your patience. We're going to start by talking about popular sovereignty, which is the idea, the principle that government exists because it is a creature of the will of the people. It's subject to revision and even overturn when the will of the people no longer supports it. It's the idea of popular sovereignty. We're going to move then to the powers under the Montana Constitution. Sometimes we think about those as separation of powers or the structure of government. I'm going to talk about two different aspects of the structure of government. One is the separation of powers between the branches of state government, and then the other is what we call sometimes the vertical separation of powers between the state government and local government. And then we will move into those state constitutional rights. And finally, I want to leave time for questions. That said, if you have a question in the meantime, I am open to being interrupted, and Professor Conley said that she will field questions from the chat and interrupt me before I move on if it's appropriate. Otherwise, we'll get to those questions at the end. So the if you just take like look at the headings within the Montana Constitution, this is what you will see. So each of the articles of the Montana Constitution deals with a different substantive component of the Montana Constitution. Starts with a preamble. It's beautiful. I don't have time to cover everything that I want to, but I will show you the preamble on the next slide. Then moves into the relationship between the United States and the state of Montana. Article 2 is the Declaration of Rights, where Montanans' fundamental rights are found within the Constitution. And then we get into the structural provisions, starting with general government and going forward and ending with constitutional revision. So we're going to touch on a number of these different articles tonight, but unfortunately, it would take a semester um, to go through the Constitution to hit each of the articles. Okay, so starting with popular sovereignty, we see this in the preamble to the Montana Constitution, and you might be familiar with it. It's like a kind of like a poem. It explains the purpose of the Constitution. The preamble, there's always kind of interesting conversations in constitutional law about what you do with a preamble. If you use it to give weight to your interpretation of other constitutional provisions. But it's a declaration, a purpose, an explanation kind of what we're doing with the Constitution. So the goal here is to secure the blessings of liberty for this and future generations. And we do that through ordaining and establishing this Constitution. And like I mentioned before, the next part of the Constitution is Article 1, the compact with the United States, and then we move into the Declaration of Rights, which we have many more rights under the Montana Constitution than under the federal Constitution, and the Bill of Rights. And the Declaration of Rights starts with these two provisions that really reinforce this concept of popular sovereignty. Article 2, Section 1 says all political power is vested in and derived from the people. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. So this is an expression of what the Constitution is, what government in a representative democracy like ours is. The government has the political power that the people have given it. And the people give that power to the government through the Constitution. Article 2, Section 2 gives another strain of the same theme. The people have the exclusive right of governing themselves as a free, sovereign, and independent state. They may alter or abolish the Constitution and form of government whenever they deem it necessary. And so we're going to talk next about how the people would do that. And that's through the process of constitutional revision. So Article 5, which refers generally to the legislative power, points out that the people reserve to themselves the powers of initiative and referendum. And these are the powers by which people can amend the Constitution. Article 14 deals specifically with constitutional revision. There are two different ways in which we might see an issue on the ballot that we can vote yes or no on. Do we want to amend the Constitution? The first is through the initiative. And what an initiative is something that comes from a ballot proponent, an initiative proponent. So a person or an organization or group of people decide the Constitution should really say something that it doesn't already say, or that it should be amended to get rid of some language that exists. So in order to do that, they need to propose the initiative. It goes up to the Secretary of State. There's a review process by which the Attorney General takes a look at it, looks at the proposed initiative and the ballot statement that would go on the ballot. And if that's approved, then that goes back to the proponent of the initiative to go get enough signatures to get the initiative on the ballot. And that can be a time-consuming process. It is a time-consuming process. It can be an expensive process to get enough signatures to get a proposal on the ballot. But if it crosses the threshold and there are enough signatures, then when it comes time for the election, the voters get to choose. And it's a simple majority. If more than 50% of the voters say yes, then the Constitution is amended. The referendum power refers to something related. And it's the very same thing once an issue gets on the ballot, but it's a different route to the ballot. A referendum comes from the legislature, not from an individual or an organization that wants to amend the Constitution. So the legislature can pass a bill, a legislative referendum, by a two-thirds majority and place an issue on the ballot for the people to amend the Constitution. And finally, we have we have the question of whether to call a constitutional convention. So initiatives and referenda have to deal with specific proposals. Here's one thing that we want to change about the Constitution. Constitutional convention, the question of whether to call a constitutional convention is a broader question. Do we want to rethink things? So this can go to the voters again through a two-thirds vote of the legislators by an initiative. So the same route as to amend the Constitution can be used to call a constitutional convention. And then finally, we have periodic submission so that every 20 years, automatically, voters are asked if they want to call a constitutional convention. And that's the question that they're asked. Do you want to call a constitutional convention? It is not a question about whether or not to amend the Constitution, but instead, or to replace the Constitution, but instead to convene a convention to consider making bigger wholesale changes to the Montana Constitution.
And Professor Van Kley, in the federal Constitution, can you amend it through initiative or referendum?
You cannot. Thank you, Professor Conley. The Montana Constitution is very much easier to amend than the federal Constitution. This is common for state constitutions, although not all states are quite as constitutions are quite as easy to amend or have as many different paths to amendment as the Montana Constitution. Um, Under the US Constitution, it is very challenging to get an amendment passed. And it needs to go both through federal Congress and through the states. And it requires supermajorities at both levels. So if you were wanting to amend the US Constitution, the way to try to get that to happen would be to talk to your local senator or representative at the state or federal level, and it would require a whole lot of process and a whole lot of votes from elected officials in order to make that happen. At no point would it actually hit people's ballots for them to vote yes or no on. Okay, so turning to the separation of powers under the Montana Constitution, Article 3 lays out the general structure of government and provides that the power of the government of the state of Montana is divided into three distinct branches. No person or persons charged with the exercise of power properly belonging to one branch shall exercise any power properly belonging to either of the others, except where this Constitution expressly says otherwise. And the idea with a separation of powers framework is to limit the power of any one branch, which could otherwise kind of take control of the process. It is intended to protect minority interests. It is intended to prevent an out of control government from, or government actors, officials, from kind of trampling the rights of the people in order to extract what they want from government. Our separation of powers is similar to that under the federal constitution and that of most other states. And we think about three separate branches: the legislature, the judiciary, and the executive. And each of these branches is even further divided. So you have different individuals within each branch of government that has different job to do. The legislature is broken up into two houses. We've got the Senate and the House of Representatives. And in order to successfully become law, a bill has to pass through each of those houses, both of those houses. The job of the legislature is to pass laws and to determine how money is going to be spent, to appropriate money to others within government when the legislature is not in session. Then there is the executive branch, and we generally think of the executive branch under the Montana Constitution as the governor. And that's true to a great degree. The governor is the most powerful member of the executive branch, but the governor is not the only independently elected member of the executive branch. The attorney general, the secretary of state, the state auditor, and the superintendent of public instruction are also independently elected members of the executive branch. The job of the executive is to execute the law. So the legislature passes the law, the legislature makes the law, and then the executive branch kind of takes the baton. And from there, it's up to the executive branch to enforce and put into effect the law that the legislature has passed. And we have the judiciary. And the judiciary includes courts of limited jurisdiction. Those include justice courts, city courts, and municipal courts. Collectively, courts of limited jurisdiction receive about 5 times more cases than district courts, county courts do. So that is the most likely place for an individual to have an interaction with the judiciary in Montana. There's also district courts, county courts, and they oversee felony matters and civil claims that involve more significant amounts of money. And then the Montana Supreme Court hears appeals from district courts and hears is the court of last resort within the Montana system. The job of the judiciary is to interpret the law, and that means interpreting the law that the judiciary or that the legislature passes, and it also means interpreting the Constitution.
Professor Van Kley, is it common for other states to have judicial elections like we do?
It is, in fact, common to have judicial elections. It is not universal, but it is the most common way in which judicial officers are selected in states. There is a lot of room for improvisation among state governments in terms of how to select judicial officers. So in the federal system, there are no judicial elections. The president nominates and the Senate confirms judicial nominees. Those judges, once they are confirmed by the Senate, serve for life unless they are impeached. In Montana, our judicial officers are responsive to the people through judicial elections. And that isn't a universal feature among state constitutions, but it's fairly common. It's more common than to have an appointed judicial branch.
And are there term limits or age limits for judges in Montana?
In Montana, judges are not subject to term limits, but they are subject to reelection. And there are not age limits. Those are some things that other states have experimented with, though. And the Constitution does not expressly speak to those issues, but we do not have those term limits or age limits in Montana. Okay, so turning to the legislature power. And legislative power, I just want to point out a few things in the Constitution that are directed to the legislature. This is in no way an exhaustive list of the obligations that the Constitution places on the legislature. Again, the legislature's primary job is generally to pass laws. Um, but a few places where you might see an intersection between what you think about as your rights in Montana, um, and the constitutional language that directs to the legislature the question of how to implement those rights. So Article 10 has to do in part with education, and it says that the legislature shall provide a basic system of free, quality public elementary and secondary schools. This tells you, under the Montana Constitution, this is a requirement. This is something that the legislature has to do. There's nothing like this in the US Constitution. We don't have a system of public schools under federal law, under the federal Constitution. And we also don't have language like this that tells Congress, under the US Constitution, Congress, you need to do this thing. But the Montana Constitution does tell the legislature that it is not a suggestion, it is an imperative. The legislature must create this system of public schools. It also provides that the legislature shall provide for the administration and enforcement of the duty to maintain and improve a clean and healthful environment in Montana for present and future generations. Again, nothing like this in the Montana or in the US Constitution. This is language that is unique to the Montana Constitution. And you can think about this if the legislature weren't obligated by the Constitution to do this, how would these rights exist, right? So if you have a right to an education under the Montana Constitution, but nobody has to create a system of public schools, then what meaning does that right have? So these are some interesting features of the Montana Constitution that really tell the legislature it needs to take action. Turning to the executive power, again, the governor is usually kind of what people say is maybe coextensive with the executive power. The governor is the head of the executive branch, but he's not the only independently elected executive officer under the Montana Constitution. We have these other positions that we have to vote for, and who are responsible for have independent duties, for which they are responsible for separate from the direction of the governor. In Article 6, Section 4 reinforces that it is the governor who is the fallback executive officer. The executive power is vested in the governor, who has a responsibility, shall see that the laws are faithfully executed. Additionally, the legislature can create other duties for executive branch officials outside of those provided by the Constitution.
That's so interesting. I always thought that the faithful execution duty would fall more specifically on the Attorney General.
Yes, it is interesting. So the Attorney General is the chief law enforcement officer and the chief attorney for the state. And one potential way to think about this differently is that the Attorney General has the duty, and this is not spelled out in the Constitution, but the duty of enforcing the laws as the chief prosecutor, right? And the duty of defending or representing the state before the judiciary. But certainly that involves executing the law to some degree as well, as do the roles played by the Secretary of State, Superintendent of Public Instruction, and the Auditor. Turning to the judicial power in Article 7, the judicial power is vested in one Supreme Court. This is an outdated photo, I will point out. I looked for, but I was unable to find a photo that includes Justice Bidigary and Chief Justice Swanson, who have replaced some of the justices in this photo. The judicial power of the state is vested in one Supreme Court, district courts, justice courts, and such other courts as may be provided by law. And the legislature has created the water court as an example of another court that may be provided by law. Article 2, Section 16. If you remember, Article 2 is the Declaration of Rights part of the Constitution, the part of the Constitution that says, here are all of your rights as a person interacting with the government of the state of Montana. Article 2, Section 16 says that we actually have a right to access the courts. Courts of justice shall be open to every person and speedy remedy afforded for every injury of person, property, or character. Right and justice shall be administered without sale, denial, or delay. Another example of where you will start looking at Article 7 if you want to understand the judicial power under the Montana Constitution, but you'll see references to it elsewhere. And Article 2, Section 16 shows tells the individual, right? Not only is there a judiciary established under Article 7, but here are some rights that you can expect to be enforced by that judiciary. You actually have an affirmative right to go to court to seek a remedy.
Professor Van Kley, I know a lot of states have intermediate courts of appeal like they do at the federal level, but Montana doesn't. What's your crystal ball? Do you think we'll ever have intermediate courts of appeal, or do you think that our population just doesn't warrant another layer of courts?
That's a very good question. The right now we just have we have the courts of limited jurisdiction, and there's an opportunity to appeal those matters to the district court. But for felony criminal cases and larger dollar civil cases, or constitutional challenges, you will file directly in district court. And once you have a case in district court, whether it's coming up from from a justice court or was filed there originally, the only place to go is to the Montana Supreme Court. Most other states, I think at my last count, 42 states have an intermediate appeals court that really helps the state Supreme Court manage its docket. But we don't have that. It is under the Constitution. An intermediate appellate court is such other court as may be provided by law. The legislature could have the ability to create that intermediate appellate court. I think it's fair to say that the Montana Constitution or Montana Supreme Court does have a pretty heavy workload. They have a lot of cases before them, but I don't think we are in crisis mode. And so I don't have I guess I just don't have a crystal ball. I don't know what it would take to really change that equation, but I'm not aware if there's ever been serious consideration into creating an intermediate appellate court in Montana. There hasn't been in recent years, and I think it probably will take a a workload that a court of 7 justices cannot handle in order to alter that equation. Because they continue to generally resolve cases fairly quickly, and they do resolve cases on the merits. I think we're not in crisis mode now. And if we were to get to that point, then the ball would be in the legislature's court to create an intermediate appellate court to reduce the workload. Okay, so I want to turn to one other aspect of the separation of powers before we talk about some of the unique rights that exist under the Montana Constitution. And this is the idea of vertical separation of powers. So when you talk about the US Constitution, you talk about federalism sometimes, right? The federal government can't interfere with what we think of as the state's prerogatives, state rights. Um, so the federal government, what Congress can do, is pass laws in certain areas, but it doesn't have the power to universally pass laws governing, land use, your private property. You don't go, you get zoning laws from local government, not from the US government. So the US government is very powerful where it has the power to act, but it doesn't have the power to act everywhere. And federal power is limited to some degree by state power, which is much broader. We have a not quite a parallel situation, but sort of a question of the vertical separation of powers under the Montana Constitution, where you have the state of Montana acting, but you also have local governments, cities and county governments acting, right? And they have the power to, right? They pass zoning laws. They deal with taxation. They have city ordinances that tell you, how to get a permit to engage in a protest, for example. So we have local government also acting in the possibility for conflict between the state and local government. Now, state constitutions, generally, there are two camps for state constitutions and how to deal with the issue of local government. There's what's called Dillon's rule. And an example of that is found in the Iowa Constitution. This is from a case from 1868. Municipal corporations, city governments, owe their origin to and derive their powers and rights wholly from the legislature. It breathes into them the breath of life, without which they cannot exist. As it creates, so may it destroy. If it may destroy, it may abridge and control. So Dillon's rule, which is a most common way to deal with local government in state constitutions, is the rule that state government controls. And it can give power to local government, but if it doesn't give power to local government doesn't have any power. And if it gives power to local government, then it can take it away. And there's home rule. Michigan is an example. Texas is another example. Local government is a matter of absolute right, and the state cannot take it away. Home rule model is similar to what we think of as federalism under the US Constitution, where the state just has powers that the federal government can't take away. The Montana Constitution kind of splits the difference between these two. Article 9, Section 4 says that a local government unit without self-government powers has the powers provided or implied by law, the powers provided or implied by the state legislature. And it goes on to say that powers of incorporated cities and towns shall be liberally construed. So maybe there's some deference, there's a little bit of generosity given. But if you don't have a self-government charter as a local government unit, you have the power that the legislature says that you have. Then you go to Section 6 within the same article. A local government unit adopting a self-government charter may exercise any power not prohibited by this Constitution, law, or charter. So the legislature still has the ability to take local government power away from these local government units that have chosen to exercise self-government powers through a charter. But they don't have to wait for the legislature to speak to give them power. They are taking for themselves, by passing a charter, the ability to speak even absent legislation that tells them that they can. Okay, turning now to we're just going to get some of the hits of the unique rights under the Montana Constitution. We'll talk about the inalienable rights provision. And if that sounds kind of confusing and broad, you're right, it is. We'll turn to dignity and equality, the right to participate and the right to know, and the right of privacy. First, the inalienable rights provision. This is Article 2, Section 3. So this comes right after Article 2, Section 1, popular sovereignty, Article 2, Section 1, self-government power that relate to, what is a constitution and what are the powers that the people have no matter what. Inalienable rights provision provides a broad grant of power to the people. All persons are born free and have certain inalienable rights. They include the right to a clean and healthful environment and the rights of pursuing life's basic necessities, enjoying and defending their lives and liberties, acquiring, possessing, and protecting property, and seeking their safety, health, and happiness in all lawful ways. In enjoying these rights, all persons recognize corresponding responsibilities. If you read this and your mind is like going a little crazy, thinking of all of the possibilities that are found within this provision, I mean, you're right, they're there. Free and certain inalienable rights. So an inalienable right is a right that just can't be taken away. It belongs to you no matter what. Um, the right to a clean and healthful environment is something that has been in the news lately. The Montana Constitution is the first constitution to have an express environmental rights provision. They popped up in a few other constitutions afterwards. And there has been some litigation dealing with whether or not this right restricts the legislature from passing certain laws that might have a negative effect on the environment in Montana. It's been determined that it does, in fact, provide some limitations on legislation.
And
You-
one question in the chat is a great question. It basically identifies that for some rights where we have corresponding duties, we have a specific elected representative. For example, the right to education, we have the superintendent of schools, but we don't have a corresponding executive official whose duty it is to enforce this particular right of clean and healthful environment. And the question is, was that intentional or was that just a gap? Or does that tell us something about this right and how we can understand it?
That's a really interesting question. I've not made that connection before, right? Because um, with both the right to education and the right to a clean and healthful environment, you do see a constitutional provision that is giving the ball to the legislature, right? Now do something about these rights, legislature. When it comes to the right to an education, we also have the superintendent of public instruction who is tasked with educational responsibilities, right? That the legislature provides. I don't, I haven't thought about this provision in relationship to those elected offices before. Um, but I do think that that's a very good question is, does having an independent elected official tasked with a specific sort of area, does that provide further enhancement for the right? Although I think the answer is probably not necessarily. And the reason for that is that the superintendent of public instruction is a constitutional officer. We elect the person who will be the superintendent because the Constitution says that we will elect that person. But the duties set forth in the Constitution applicable to the person are only those duties that the legislature assigns to them. So it still gets channeled through the legislature, even though there's an independently elected executive branch official.
And
Um,
I always thought about this right being enforced by Department of Environmental Quality, but that's not a constitutionally created agency, right? That agency could disappear at the will of the legislature or the governor.
Yes. Yes. So the Department of Environmental Quality is a created by the legislature, but the officer, the chief officer is appointed by the governor, right? So there's a something more of a sense of permanency because it is a legislative creature created by the legislature. But when you vote for a governor, you are voting for policy on the environment, for example. That's the way that our system works, with the governor putting the person into the head of that agency who's going to do most of the work that really involves enforcing the environmental laws of the state.
This is maybe getting a little too in the weeds, but with these legislatively created agencies, the governor appoints the head of these agencies and they don't have any removal protections, right? A new governor can say, "You're my new person," without any sort of legislative control.
Yes. And one thing that's really interesting in Montana is under the Montana Human Rights Act, most state employees are protected from political termination. So you cannot, if you work for the state, say you work for DEQ and you have some role to play in sort of processing permits, you do environmental assessments for DEQ. You can't be fired for political reasons. The legislature passed the Montana Human Rights Act, which it saw as an enforcement of another provision within the Montana Constitution that we'll talk about. Um, and under that provision, it's only those under the Montana Human Rights Act, it's only the kind of core staff of independently elected officials that can be fired, removed from office for political reasons. Okay, turning to that other provision, Article 2, Section 4, it's another big one. Individual dignity. The dignity of the human being is inviolable. Something different than inalienable, but very similar, maybe, right? So an inalienable suggests that it's yours, and no matter what anybody tries to do, it can't be taken away. Inviolable suggests that it's yours and nobody's allowed to violate it, maybe. The second sentence, no person shall be denied the equal protection of the laws. Then the third, neither the state nor any person, firm, corporation, or institution shall discriminate against any person in the exercise of his civil or political rights on account of race, color, sex, culture, social origin or condition, or political or religious ideas. Um, so there are a lot of questions. The Montana Constitution. It's ratified in 1972. We've been living under this Constitution for 53 years, and there's no shortage of questions about what to do with this constitutional provision. So if you look at just the first sentence, the dignity of the human being is inviolable. Does that mean that you can go to court if you think that the government has violated your dignity? It's an open question that's been kicked around in different cases, but we don't have any real answers for it. Where this language traces to, it actually comes, its direct precursor is the Constitution of Puerto Rico. And the Puerto Rican Constitution included a dignity clause in response to the Holocaust and World War II. And so that's why you see dignity tied to these sort of anti-discrimination provisions, right? Because it violates somebody's dignity to treat them, to subject them to um, inhumane treatment, specifically because of their membership in some category, their race, their religion, their ethnic background. But the question that it asks is also, does it just violate the right of dignity to subject somebody to what you think of as inhumane treatment, to not afford to them to not give them all of the autonomy that a person might expect if they say this interferes with my personal dignity. The second sentence, the no person shall be denied the equal protection of the laws. This sentence is similar to what exists under the federal constitution. Um, and this sentence means that the state or local government, right, through the laws, government cannot unjustly discriminate against people. Then the final sentence just raises a lot of questions because it applies not just to the state, not just to government, but to persons, firms, corporations, or institutions. It's very unusual to have constitutional language that purports to limit what individual people can do in their interpersonal interactions with other people. There might be some limitation here because it refers to the exercise of civil or political rights. But when you think about civil rights, you think about civil rights, the civil rights movement in the United States, for example, we're talking about access um, to businesses, access to not exclusively, but at least in part, access to restaurants, access to hotels, right? So this last sentence of this provision suggests that our Constitution is actually telling individual people you're not allowed to discriminate against other people on these bases. Okay, turning to the right to participate and the right to know.
Can I ask you a question about that last one?
Yes.
Do you know, have there been successful civil actions against private actors pursuant to this particular provision?
No, there have not been, but the door is not entirely closed either. So, because the legislature passed the Montana Human Rights Act, it provided a cause of action for most of these kinds of discrimination in employment or public accommodations. And so, the legislature, by creating that right of action, maybe prevents any question about these constitutional claims from coming forward because you can just look to the law, the statute, the Montana Human Rights Act, go to the Montana Human Rights Bureau and pursue a claim there.
And another question about this provision in the chat is, have felons used this provision to enforce their care while incarcerated?
Yes, they have in fact done so. So there's a case called Walker v. State in which an individual claimed that he was subjected to incredibly inhumane treatment during his incarceration. He argued that it interfered with his right of dignity, right? Being subjected to unclean, hazardous conditions, solitary confinement, exposure to feces, just really awful conditions, that violated his right to dignity. He also brought a cruel and unusual punishments claim, and the court read them together, right? So the court relied on his right of dignity, pointed to it, says this offends his individual dignity, but kind of used it as what somebody else has described to me, and I think kind of aptly, as a force multiplier for the cruel and unusual punishments clause. So really the claim that the court recognized is a cruel and unusual punishments clause, but it looks to the dignity clause the way you might think about looking to the preamble when you look at the Constitution as a whole to kind of give meaning to like, what are we doing here? What are we talking about when we talk about cruel and unusual punishments, about what it means to be a person dealing with government? Okay, right of participation and the right to know are two ways in which individuals interact with government, local and state government, all the time. The right of participation provides for the opportunity, a reasonable opportunity for citizen participation in the operation of agencies prior to the final decision as may be provided by law. So there are some limitations here, right? So what this says is before an agency is going to take final action on something, and we can use DEQ as an example. Before an agency grants a permit, makes a final decision, there has to be some opportunity for some reasonable opportunity for citizens to get involved in that process and to voice their opinion. It does not obligate the agency to take any specific action in response to that right of participation. So they have to listen, but they don't have to heed the comments that people express. They don't have to agree. They don't have to actually take them into account, but they have to give an opportunity for those individuals to state their opinion so that they can be heard. The right to know comes right after, and it's a lot broader. No person shall be deprived of the right to examine documents or to observe the deliberations of all public bodies or agencies of state government and its subdivisions, except in cases where the demand of individual privacy clearly exceeds the merits of public disclosure. So we're not talking about, as with Article 2, Section 8, we're not talking about reasonable opportunity. We're not talking about final decisions as may be provided by law. We're talking about something that reads like a pretty absolute right, right? There's a presumption of open government in Montana. And so if the government has documents that relate to the government doing its job, of the government, agencies, city council, planning board, right? If they're having meetings, the people have the right to examine those documents. They have the right to observe those deliberations, unless this specific carve out is met, unless you have privacy interests that clearly exceed, that clearly outweigh the merits of disclosure. There have been other exceptions that have been recognized as well. Generally, they're construed narrowly, and there is this presumption of open government in Montana. No other state has a right to know like this one. Most of the other states, all of the other states, have something like this as may be provided by law language when you talk about a right to know. Gives the legislature the ability to define and potentially constrain that individual right. One more right that I want to get to, and I know I've talked a lot and I want to get some time for questions, but this is the right of privacy under the Montana Constitution. It's also something different from the federal Constitution, uniquely broad in Montana. Other states do have rights of privacy, but they're generally limited to some context or relate specifically to like searches and seizures, things that have to do with the criminal justice system. Ours reads, the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. And you can think about the right of privacy as kind of branching into two different areas. One is what's called informational privacy. And this is the right to be free from surveillance, the right to protect your information from the government, right? So that my right to lock my door, to not allow the government into my house, to lock my computer and not allow and tell the government that's not allowed into my computer, can't have access to this private information for me. The other aspect of is what we call autonomy privacy, which is the right to control matters that relate like deeply and intrinsically to my own sort of personhood. There's a lot of interaction between this concept of autonomy privacy and the right of dignity potentially as well. So when you talk about autonomy privacy, you might talk about, for example, the right to contraception, abortion. One thing that is always a kind of a perennial topic in this space is the right to control the manner of means of your death for terminally ill people, but sort of the right to make personal decisions about matters, particularly matters relating to reproduction, without the government getting involved, and that's autonomy, privacy.
So
And
with privacy of information, so much of what we do with our electronic information is either national or internationally hosted. And I'm curious how can we have a heightened right in this area when much of what we're using is not from Montana?
yes, this is a really hard question, right? It's not from Montana. It's actually not the government that we're really concerned about necessarily either, right? So, does the state of Montana have more information about me personally, or does Google? Like, Google has all of the information. And I might be particularly concerned about the state of Montana, like in a criminal proceeding, getting a warrant and getting that information. But it's not the primary concern with a private entity having all of this information about us. And there's a real question about what courts can do in a situation like this. I think the answer is probably not very much without legislation. And so what it takes is strong consumer protection, strong privacy laws that have to come through the legislature. And we can look to the Montana legislature to do some of that. But a lot of it is going to have to come from, right, there are limits to what the state of Montana can tell Google. Um, and so to really give effect to that, to really prevent wholesale collection and storage of private information, you would need legislative action, and you would need legislative action at a federal and probably cooperative international level.
Yeah. There is a question in the chat. I'm not sure if it would fall within the Montana Constitution, but I'll throw it out there. I have heard that in Great Falls, I can't be charged for trespass if I walk across my neighbor's yard. What do you think?
I don't know. I think generally, as a matter of state law, right? As a matter of state law, state trespass law would say that that if this is your property, you have the right to exclude people from that property. And if somebody violates that, if you say, this is mine, um, they can be responsible for trespass. I don't know if there's something different about Great Falls that really changes the nature of those property rights. It's really interesting.
Yeah.
I will just point out, like we talk about, I mentioned the inalienable rights provision. I talk specifically about the right to a clean and healthful environment because it's something people are talking about right now, and there's been litigation. But this also says acquiring, possessing, and protecting property is an inalienable right under the Montana Constitution. We recognize corresponding responsibilities. That subject suggests that the Montana Constitution does really privilege private property rights, and that would include the right to exclude others from your property.
How would you say that we should try to understand this corresponding responsibilities language?
Yeah. It's a really good and hard question. So, what this means when you say in enjoying these rights, all persons recognize corresponding responsibilities, that suggests the right's not absolute, right? So, um, yes, you have this right, but you also have responsibilities, right? And so if you have a right and you have responsibilities, that means that you can't acquire property, for example. That's an inalienable right, but you can't acquire property outside of the ordinary legal channels. One way to look at this, and I don't have a comprehensive answer, I've thought about this a lot and I struggle to tell you exactly what I think the answer should be. But if you look at enjoying, defending lives and liberties, acquiring, possessing, protecting property, seeking safety, health, and happiness in all lawful ways can be used to kind of modify all of those. Um, and that would suggest that actually, yes, we're saying these are inalienable rights, but the legislature probably has pretty broad discretion to define, for example, your property rights and to outline how property rights are acquired and maintained.
It almost just seems like a good faith sort of norms creation.
Yes, yeah, I think that's right. It's saying these things are really important to us,
Hmm.
but legislature, we trust you. We trust you to protect these rights.
Hmm. Well, that was a fast hour. I could talk with you about the Montana Constitution for many more hours, but that's it for us. That's it for Citizens Law School for this year. Again, please, when you'll be getting a survey, reach out and let us know how we can change it. If you have ideas about topics or things you want to learn about, what worked, what didn't. And thank you so much, Professor Van Kley, for your expertise and your time and sharing it with us. We truly appreciate it. Take
Thank
care.
you.